Welcome to another episode of Legal for Tech, the podcast. So, guys, you do recognize my voice. It's always Rosie here. And as I've said many times, this is just a group of students and young professionals who are very interested in anything that has to do with technology and, yes, it's regulation. So, today I'm joined by my friend and great colleague and also producer of this podcast, Giacomo Di Gregorio. Hi, Giacomo. Great to see you.
Hi, Rosie. Great to see you as well.
And we are interviewing one of our idols. I can say that because it's true. We're calling another Italian person, finally. She's also from Rome, and she's also a very big expert in the field of AI regulation in the European Union. Hello, Laura Caroli. Great to see you.
Hi, thank you for having me.
It's such a pleasure to finally get to talk to you. We are very excited for this podcast interview today, especially with everything that's happening with the AI Act, the Digital Omnibus, the Parliament issuing a draft report. Oh my God, we're literally on top of the news today with you. So, before we start discussing all of these topics, tell us something about your career. Like, why are you so knowledgeable of the AI Act? I'm sure our listeners will know, but let's refresh their memories.
Well, I had the pleasure of being one of the people who had to shepherd the AI Act from uh, um, from start to finish on the Parliament's behalf, because I was working for one of the two co-rapporteurs, leading members of the Parliament who were responsible for the file. So my former boss was Brando Benifei, Italian member from the S&D group, so Socialists and Democrats. He was sitting in the Internal Market and Consumer Protection Committee, which had the lead responsibility for the AI Act in conjunction with the Committee on Civil Liberties, for which the rapporteur was Dragos Tudorake, Romanian from Renew Europe. So we had to basically always work in conjunction with each other and go lead the process together.
You were one of the, as you said, the key negotiators of the AI Act on behalf of Brando Benifei. From inside the room, what did the negotiation process really look like? What
Mm.
was most different from the public perception of how this law came together?
Okay, so first of all, it might be useful maybe to explain what I did exactly, because I didn't just, observe and draft press releases and stuff. Basically, it meant that uh, we had to be locked in a room with our group advisor and our co-lead rapporteur. So in this case, Dan Nikita, who was the assistant of Dragos Tudorake, and his own group advisor. The four of us all together drafted every single official document that was the Parliament's position on the AI Act from the very beginning. So from the draft report, then we received 4,400 amendments because all the political groups were particularly interested in the file, and every member wanted to be visible on it, so everybody wanted to chip in. We had to turn these 4,400 amendments into a series of compromises that we had to present to our colleagues, meaning one per political group, usually one member, so one assistant and one political advisor. So we had to chair all these meetings, and then the most political issues were sorted out with the members, but the rest, so 80% of the file, was led by us. So me and my co-lead, Dan Nikita. And when it came, so this until the very end, until the vote on the Parliament's mandate, and when it came to the following legislative phase, which is called the trilogue, when the two co-legislators, namely Parliament on one side and Council on the other, come together with the Commission as a as they say, honest broker. Maybe I will say a few things about this later. They come together, the three of them, and negotiate on the basis of each other's mandate. So this means that basically, in a normal week, you have a couple of technical meetings that last very long hours with everyone, in which me and my colleague needed to voice the parliament's position and negotiate, with our colleagues listening to us and making sure their position was also respected, and that we were not contradicting the parliament's mandate, and be there to respond live to the objections and possible counter proposals and formulate proposals on the spot, etc. And then we would have also informal meetings where we would be directly discussing with the council and the commission to find solutions, to prepare. It was a very frantic type of work, very intense. That phase lasted like 6 months. It was the whole of the Spanish presidency, basically. And so we were running against the clock, but somehow we managed. So yeah, this is what I did, basically.
Well,
And then, of course,
basically at the end. Yeah.
when it came to the remaining sticking points that were very sensitive, of course, this would be sorted out in the political trilogues. So meaning that my boss would speak on behalf of the parliament together with Dragos Tudorache, and there would be the undersecretary of state, the secretary of state from Spain, and the commissioner, Breton mostly, to negotiate in the room. So imagine very official meetings, very formal, but the rest was us, basically.
In terms of the provisions, you said there were loads of amendments. It's a number that we can't even kind of foresee, considering the AI Act. What's the part that was most subject to litigation, to attrition? Which part would you say, we really had an issue here, we really had to negotiate hard on this?
Okay, so I would say, first of all, you have to know that the AI Act was a very sensitive file and very visible file in the first place. So there was a lot of tension all the time, a lot of conflict to sort out, a lot of mistrust among the different negotiators. But of course, already within Parliament, but also then with Council, among the hardest parts to negotiate were the bans. In particular, with the member states, also anything related to law enforcement. Because, of course, now we think that a lot of the sticky points were about innovation or about the models, but the hardest part was about the power of states to use AI on their citizens. So this was the trickiest point. Then one part that was particularly difficult to negotiate was Article 6, which is the key to the whole regulation. And it took several shapes and forms. Before we found the right balance, it was really a work in progress. Like, we had to change it several times, and we were never completely satisfied. For our political group, the final result was actually a big compromise that we gave to the liberal part of the aisle, because it would allow too much discretionality to providers. And we still have the problem right now as we speak with the omnibus, but we can talk about this later if you want. And also, of course, the part on general purpose AI models was included towards the end. So Parliament took more to agree on its own position, because just after the council published its own mandate, ChatGPT exploded. So they didn't have a lot on. They didn't actually even have the word models in their own mandate, but just something on general purpose systems. Whereas Parliament really wanted to include something. And why did we want to do that? Because we knew already the power that these models would have. And especially we knew that they were the building blocks of downstream applications. And so putting some level of control already in the responsibility of model providers would have allowed us to protect a bit the future high-risk AI system providers, who would be, in many cases, European SMEs, and who wouldn't have enough control over the model, but in turn would have to bear all the responsibilities of the high-risk regime, so the bulk of the requirements of the AI Act. So we wanted to at least give them a bit more assurance against what they were working with, basically.
Well, that's a great point, because we always think of the AI Act in a way it's being sold as something that kind of trampled down innovation and everything, but like actually it's also meant to protect the reality of European SMEs who will be, of course, having to comply with the AI Act, but also risk much bigger problems coming from bigger companies that are also much more financed and backed better. If we think of something like Grok AI, I mean, it's backed by the richest man in the world. We have to think about that when we think of European companies kind of providing and developing AI. When you think of the AI Act and all the negotiation process that went behind it and that you were part of, do you think that it can be called a success story, or have we missed out on a huge chunk that will be important in the future?
Success story. Well, I have mixed feelings. I mean, I am relatively happy about the result, because I think it was, compared to the respective positions, a good balance where everybody got something that they cared about, and that is more or less still keeping the product safety structure, but also including much more on fundamental rights, which was something we cared deeply about. At the same time, I mean, I've spent the past year in the US working in a think tank in Washington, D.C. I've been looking a lot at how the US regulates AI, because it's not true it's not regulated. It is regulated. The US has liability provisions that are much stronger than in Europe. So, I mean, that's why they go to court and are charged enormous fees if they lose. But especially at state level, now the activity is particularly intense in the US. But I see that every framework they release, every bill that gets eventually signed into law, is still very issue specific and actually also very short. Like if you compare the AI Act with, I don't know, the Colorado AI Act, it's like the Colorado one is 26 pages. The AI Act is 10 times that. And, you know, et cetera, et cetera. So I think the New York race is like 7 pages. So the one on Frontier AI that was just signed by Governor Hochul in December So the US has now two bills on frontier AI, two laws on frontier AI, one in California and one in New York. It's interesting because at the time they were accusing us of, being too harsh on US companies. I mean, this is to say that I see that they approach the issue in a much different way. I've seen what they've been doing in Asia. They have a much lighter approach. There are similar concepts to the AI Act, for example, in the Korean Basic Law, but still the framework is more innovation friendly than the AI Act. We must admit it. I won't lie and say that the AI Act is an innovation-based law. We do have interesting elements that protect and stimulate innovation, but the regulation per se does not have innovation as the main objective. That's just how Europe legislates basically to prevent harm, especially when it comes to product safety, to prevent harm with ex ante measures, requirements. Having said that, there are innovation measures. There are, we put the sandboxes into law, which was a first for the EU. There are provisions on R&D exemptions, open source, specific measures for SMEs, and now possibly also for mid caps if the omnibus goes through the way it was proposed by the European Commission. So there are a few ideas there to protect innovation, and also, as Giacomo, you were saying, the whole concept of imposing obligations, also basic obligations on models, allows downstream providers to innovate a bit with a bit more assurance towards what will then be their own responsibilities. So that's it.
You mentioned it before, and we would like to talk a bit more about what is also present, so the Digital Omnibus. What do you think about this Digital Omnibus? Which is like a simple question for a probably like a difficult answer. And what worries you the most, and what, if anything, do you think the Omnibus gets right in this law?
Okay, so yeah, first of all, I don't think it's a good sign of credibility for the EU to propose the simplification of a law that doesn't even fully apply yet. I find it extremely dangerous for Europe's credibility. No, also the way that the Commission went about it, first of all, taking advantage of the European elections that changed the majorities towards the right, a council that is also more skewed towards the right, the new Commission is more skewed towards the right. The von der Leyen commissioned the Draghi report at the very beginning of the presidency. The Draghi report singles out GDPR and the AI Act as two problems that companies have with innovation. I am pretty sure that if we interviewed back then Draghi, he would not have been able to mention one provision of the AI Act. I'm pretty sure of this. He just listened to companies, and of course, companies at the time were panicking because anytime you have a new law, it will just, oh my God. I mean, companies, if you talk to them without them knowing that much from a first glance, they will say they hate the AI Act, but when you really talk and have a discussion, it turns out sometimes they don't even have to comply with it. So actually, in many cases, you cannot imagine how many companies I've spoken to that were panicking about the AI Act, and then I would say, what do you do exactly? Explain to me. Let's see. I will tell you what you have to do. And then it was always some type of use case that did not fall in the scope of the AI Act. So, and they were shocked. They didn't anticipate that. So anyway, if the AI Act is really the problem together with GDPR, at least GDPR has been on the market for a longer time and it applies already. So you might have a few more lessons learned than the AI Act, which doesn't apply. Then, of course, this was used as an excuse, knowing that it would encounter the favors of part of the parliament and many member states. Let me remind you that France, for example, and Germany were not super happy about the result of the AI Act. France, in particular, was very much fighting against it to the point that even after we found the deal and the position was finalized, they tried to organize a blocking minority in council. So until the very end, they fought against it, and we managed somehow not to block it, because at that time the international pressure was too strong for France to take responsibility just by itself to sink it. But anyway, so this omnibus was born from this type of context. And what I really don't like is that the Commission basically singled out some elements that are sometimes also very dangerous, because they are not counterbalanced, for example, by equal safeguards, but just, let's deregulate, let's cut this, let's cut that. They basically listen to industry. I know this for a fact. You just need to talk to a few people here in Brussels to know exactly what I'm talking about. And in some cases, they reopened very sensitive political agreements that were taken even at the very last trilogue. And by doing so, they really undermine also the credibility of their own offices and of the overall political process. If you read in the omnibus, at some point you will see the impact on fundamental rights is not perceived to be substantial, these measures, because these are purely technical. I'm sorry, no, this is not the case. They are reopening points that are very political, and what I'm the most scared about is that by doing what they're doing, by proposing this simplification, they are now risking to reopen the whole file. Because you will see in the amendments, we will see a lot of provisions that will be reopened. I've seen ideas to reopen Article 25, for example, which is the value chain, by including possibly more responsibilities for model providers that were now mostly sorted out with the code of practice, 1 year of negotiation of this code of practice, very nice co-regulatory effort with industry and other stakeholders such as civil society. Well, now let's reopen it again. Or some will reopen the bans. Some will reopen definitions that are crucial in the AI Act and that can really spark a lot of conflict and can drag on for months, just for the sake of, just for this postponement of the timeline and whatever. By the way, even this postponement of the timeline. First of all, harmonized standards are not mandatory to be in place in order for the regulation to take effect. Companies can deal without harmonized standards, even though they are very important and everybody understands how important they are, but legally they are not necessary to implement the AI Act. Let me be very clear about this. So this cannot be an excuse per se. And they are using it as one of the main arguments for this simplification. Then you can also tell me, okay, the member states are late in building up their enforcement structures. Fine. This is a good reason because actually this is needed by the AI Act legally. But also the standards. I'm in touch with standards experts. I also participate when I have time to the meetings of the Sense and Elect Committee JTC 21 that is now tasked with producing these future harmonized standards for the AI Act. And they are now at the final stages. The Commission has really pushed them to accelerate their procedures, and they should be ready by the end of the year, more or less tops. Some of them are already at the very final stages, like the quality management system was already sent to public inquiry in December. So this is really the pre-final stage. So I don't think that starting from December 2026, they will need one more year to be able to comply, and actually 1.5 years, as the Commission is proposing now, for harmonized sectors, such as medical devices, lifts, machinery, etc. So all in all, there are many problems and many arguments to criticize the Commission for this endeavor.
Well, the omnibus wasn't exactly, let's say, the greatest act of the Commission potentially when it comes to the AI Act. Coming from your kind of parliamentary background as well, how do you think the Parliament welcomed the proposal of the Commission of the Digital Omnibus? Did they make any comment on it? Do we know how it was received?
Yeah, of course we know. First of all, it's not that the Parliament is, and especially on the left, they are not necessarily against the idea of simplifying, and me either. We just think that this proposal is not simplifying anything. If anything, it's just reopening political points instead of, streamlining. There are some points where they do it, but they are really, if you talk to companies, they don't necessarily think this is simplifying. Just I put it just there for you. And of course, on the right, they find an opportunity to listen to industry, to become champions of, let's deregulate everything, let's support innovation. So of course they will jump on that wagon. Now not only the majorities are different and more skewed to the right, but also some members within the right do not react the same way as the same people occupying the same positions in the past did. For example, ECR was split when we were negotiating the AI Act on the use of by the state of surveillance technologies. If we won the fact that the use of remote biometric identification in real time is very, very restricted in the AI Act, very narrow. It is also because the Polish ECR members were particularly sensitive to the dangers that this use of surveillance techniques by the state can have on the rights of citizens when it is abused. They remember their history from their past. Now, apparently, this group of members has changed. So, whereas in the past they counted for a big chunk of the ECR, like them and the Italians form the biggest chunk of the ECR. Now it's much more mixed, and so they I'm not even sure they hold that very strong positions. Some of them are younger, so they are a bit less sensitive. Also, we had ID in the past. Of course, they were not a big group, thank God, before, but the French ID, so from Le Pen, were actually almost always in agreement with the Greens. This might surprise you, and it surprised them as well. The Greens were like, what did we say wrong? Oh my God. They were not prepared for this. But I was surprised all the time. They were saying, but we should protect fundamental rights. We shouldn't just have AI at all costs, and this and that. Yeah, so of course the Italians were a different story because Lega was much more listening to industry. Okay, yeah, let's deregulate everything. No, but the Le Penists were not like that, and this has changed. Even now, the patriots, etc., do not think the same way. It's a bit unpredictable. So it's really the word is really unpredictable. Whereas we had control of how the majorities worked in the past, this time is not the same. And that's why it's much more dangerous to reopen something this complex. Now, even more so with members that did not work on the file before, because many of them did not work on it before, and just putting their hands on it now without knowing the context is, I wouldn't advise that. But it's democracy.
I love that comment. Laura, we know that the Parliament has literally very lately issued a report, a draft report on the Digital Omnibus on the side of the parts that will impact the AI Act the most. You've read the report, and you've also issued a great analysis of it. Please, can you tell our listeners a bit more about your analysis and where they can find it?
Okay, so we're advertising now. Yes, I read the report. I thought it would be helpful for readers who have to work on this file for their own purposes to understand exactly how to read these amendments. It's not super straightforward sometimes. Plus, they are amending amendments, so it's it's even difficult to explain sometimes. So I have a Substack now that you can find also on my LinkedIn page. Maybe we will share the link. And I published this analysis of all the amendments of the draft report. Now, explaining also that, so now you have these new two co-rapporteurs. By the way, both of them have never worked on the AI Act before. I mean, not on the legislative part, just on the of course, McNamara, the Libe rapporteur, has worked as co-chair of the AI working group, the working group that is tasked from Parliament to surveil the implementation of the AI Act. So they have regular meetings with the Commission to check whether it's going well, etc., etc. But working on the legislative part is a different thing. And so McNamara is now rapporteur for that. And the other co-rapporteur is Arba Kokalari from EPP and the Internal Market and Consumer Protection Committee. She has a completely different view. She's very market-oriented. I've worked with her in the past on file on the budget, and I remember her being super tough, pro-industry. So we can expect some sparks there because McNamara, first of all, they haven't worked together before, and they haven't worked together on this file in particular. They had very little time to draft a report, so it's no surprise to me that the draft report is only 24 amendments long, meaning that basically what you will find in there are only the very few proposals that they could agree on. The rest will come in the amendment stage. And there you will see, meaning when every group is entitled to table amendments, which is, the deadline is this Thursday. And so next week we will we will see what we have to work with. And good luck to the rapporteurs, because there would be a bit of everything. And yeah, so did I answer your question?
Perfect, perfect. Okay, our listeners will definitely find the link to your Substack and to the article into our show notes. They already know it. I say it just to remind them. Before we let you go, one literal last question. Okay, you now you don't work within the parliament anymore right now. You have chosen a different path now, I would say. Um, do you, if you were to think of something to change, to implement, to do anew, so another type of legislation, in consideration of the AI world and what's coming out, for example, we know that now there's a social media for AI agents, which I find scary to the very least, especially because apparently the greatest topic of conversation is how do we wipe out humans from the face of Earth, which is already kind of scary to me. If you were to choose a topic where you would like to work on and you would say, okay, let's modify the AI Act in this way, or let's have another type of legislation for this, what would it be?
Mm. So first of all, I'm not necessarily in favor of reopening the AI Act every time the technology changes, because yeah, otherwise we would have to do it almost every week. But also, let me specify that the choice of a product safety framework by the Commission was, I mean, there were a lot of reasons, but one of them was the fact that other product safety laws have this type of flexibility that allows a certain degree of adaptiveness to the changes in the market. Meaning, for example, in the toy safety regulation, now regulation, it was a directive until a couple of years ago, that I had also the chance to work on. You have the requirements in the law, and then you have annexes where you put, for example, the limits of the chemical substances that can be included in a toy in order not to be toxic for a child, or I don't know, rules for flammability, noise levels, warnings that you have to put on the label, etc., etc., etc. These annexes are always amendable through a delegated act by the Commission. Why? Because it has happened very frequently that the union agency that deals with chemical substances has found scientific evidence that a certain substance has revealed itself to be more toxic than we thought. So they had to lower the maximum amounts that could be present in a toy, not to be toxic to children. So the same thing holds true for the AI Act. You can update many parts of it, including, by the way, the bans. There is an article, which is Article 112, that states that the Commission should revise every year and reassess the need for possible additional bans, or when a ban is not needed anymore, etc. For example, this has been now debated, and we will see a lot on this in the amendment stage on the Grok case of nudification tools. Yeah. So if needed, a few things can be updated. For example, also the flops threshold for powerful models can be updated, because it's normal, because at some point maybe less powerful models will become much more capable, or the opposite, only very 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 capable models will only be those with extremely high computing power. This I doubt, to be honest. I just think that if they adjust the threshold upwards, it would be because the Commission doesn't have the resources to enforce too many to investigate on too many models. But that's a sad, different story. So we have the tools. I do think that AI agents are the issue to think of right now, of course. I don't think they are excluded from the AI Act. I think they are covered. There's some you would be surprised. Um, uh, Sergei Lagodinsky, the rapporteur of the jury opinion, so the opinion of the Legal Affairs Committee in Parliament, has proposed to amend the definition of AI system in order to include AI agents. I will have to write something on this too, because I think it's helpful to have a background on this to understand why it is extremely dangerous to reopen the definition of AI and why I think it already covers it. So that's why I said prepare for surprises. We are seeing them already. So anyway, there are ways in which you can give guidance, adjust frameworks, etc., without necessarily touching the main elements of the law. So I think the structure of the AI Act for this is quite good, and it also allows for a good enforcement mechanism, because the network of market surveillance authorities that are normally enforcing product safety legislation is a structure that works quite well. That's why the Commission, one of the reasons why the Commission chose this structure. So compared to, for example, GDPR at the beginning, you remember when it was just being implemented, GDPR faced a lot of bottlenecks in enforcement, because the data protection authorities that were invested of possible infringements were the ones where the processing happened, and it was very often in the headquarters of a company, and in many cases this is Ireland for the big techs, etc. In the case of product safety legislation, including the AI Act, the enforcement happens where the product is circulating or where the infringement took place. So it can happen in any member state. So you will not have a concentration of cases in the same member state. You will have rather a much more diffused type of enforcement. Now, if you want, I can also enter into the conversation as to how complicated it would be for market surveillance authorities to speak to each other, because member states have chosen to keep their freedom to organize themselves, unlike what we as Parliament requested and proposed. And they appointed very diverse authorities compared to one another. So imagine a telecom or a cybersecurity or a data protection authority or a market surveillance authority talking to each other. They will literally speak different languages. And this is, I think, one of the biggest dangers of on the AI Act implementation. But again, this is what the member states wanted. We try to have them coordinate, to have at least one coordinating authority that would merge competencies of, for example, a data protection authority and a market surveillance authority, because again, even just these two speak very different languages. And but it wasn't what they wanted, so yeah.
Wow, there's so much to read. Like in relation to all this issue, AI Act, Digital Omnibus, what's going to come next, what the Parliament will say, the whole process of decision making that, of course, seems to be so easy when it comes from the Commission, because obviously we don't see what's behind it, but also it's a smaller group. When you think of the Parliament and all these committees, and then the conversation between Parliament and the Council, it's wow, it's a lot to follow, and we are very thankful with you, Laura, because you helped us actually untangle it as much as we could in a podcast episode, and we will keep on following your Substack, which we are great fans of, because it really is a particularly specific and very insightful piece of analysis that I think sometimes misses from the general breaking news atmosphere on LinkedIn, if I may. Thank you very much for joining us today, Laura. It was a pleasure to meet you. We hope to keep in touch in the future, and we hope you'll keep on listening to our podcast as well.
Of course. Thank you so much.
Thank you. And thank you, Giacomo, for helping me with this interview today.
Thank you, Rosie. Thank you, Laura.
This was all from the Legal for Tech, the podcast.
This episode was brought to you in partnership with DG Beetle. DG Beetle helps privacy professionals to stay up to date with the most important European documents in the AI, data and digital space every day. Curious to know more? Check out the link in our show notes.